Hey there, and welcome back to Study Hall. You know, the show that makes even the most boring topics actually kind of fun.
Kind of fun. I'd say really fun.
Okay,
Yeah.
really fun. Well, today we're tackling something that is the foundation of a democracy.
The cornerstone, you might say.
Voting, that's right. But not just voting in general, we're going deep on the John R. Lewis Voting Rights Advancement Act of 2021.
A pretty important piece of legislation, I'd say. It essentially updates and strengthens the Voting Rights Act of 1965. You know, times change and tactics change, so this act tries to keep up with all that.
Exactly. Like, imagine taking a classic car and then swapping in like a supercharged electric engine. That's what we're dealing with here. And get this, we're not just talking about the act in some like abstract way.
Oh, no, we've got the real deal here.
We have the actual text of H.R. 4, the bill that became the John R. Lewis Voting Rights Advancement Act. Have you ever, actually wondered what the nuts and bolts of a law look like? Well, get ready, because we're about to find out.
We're going in deep, folks. And it's a fascinating document, I have to say. Very methodical in how it approaches protecting voting rights. For instance, Section 2, that's where the real action is. It's all about vote dilution, denial, and abridgment, which are, the big no-nos when it comes to messing with elections.
Okay, so Section 2, that's our starting point then. Got it. But before we get all tangled up in legal jargon, can you break down what vote dilution actually means? Like for, normal people.
Imagine a situation where a group of voters, let's say they're all from the same racial group or speak the same language, and someone is trying to weaken their voting power. Like their votes just don't carry the same weight as everyone else's. That's vote dilution in a nutshell. Now, the Act lays out 3 very specific things that a person has to prove to make the case that this is happening.
3 things. Okay, sounds like we're about to lay down the law here. Lay those criteria on me.
All right. The first thing they have to show is that the group they're talking about is large enough and lives close enough together that they could be a majority in a single-member district.
That makes sense, right?
Right.
I mean, you can't dilute the power of a group if they weren't a significant force to begin with.
Yeah, makes sense. So what's number 2?
Second, this group has to be politically cohesive, meaning they tend to vote in similar ways. They're not all over the place with their choices. They've got shared interests and goals, politically speaking.
So it's about their potential to really make a difference in an election as like a united front. And I'm with you. What's the third thing?
This one's a bit more complex. They have to demonstrate that other voters in that area tend to vote as a bloc, but against the candidates that this group prefers. So even if they have the numbers and they're all on the same page politically, their votes are basically being canceled out by this opposing bloc.
So it's like an electoral tug of war, but one side has like an unfair advantage. That's messed up. And it's not just about meeting these 3 criteria either. Even if they do that, a court still has to do what's called a totality of the circumstances analysis. So it's not just about the numbers, it's about the context, the bigger picture.
Okay, totality of the circumstances. Sounds like something a lawyer would say.
Yeah.
Break that down for us regular folks. What are they really looking at?
Think of it like this. They're zooming out to get the full view of what's going on with voting in that area. So they'll look at things like, has there been voting discrimination there in the past? Is voting there really divided along racial lines? And are there any practices in place that might be making things worse?
So if an area has a history of shady voting practices, that makes it more likely that they're still trying to pull something.
Yeah. Exactly. It's all about looking for patterns. And some of these practices are really subtle. They're not like in-your-face discrimination. It can be things like oversized election districts. Those can actually dilute minority votes. Or they might require a majority vote to win instead of just a plurality. That can make it harder for candidates who are preferred by minorities to actually win.
Right, because they might not be able to get that majority if the other side is like a really strong voting bloc.
Exactly. And then there are things like, and this one's a bit wonky, anti-single shot provisions. Have you heard of these?
Anti-single shot? I'm not sure I have, no.
It gets a bit into the weeds of voting strategy, but imagine you really want one candidate to win, so you only vote for them. Even if there are multiple seats up for grabs. This can actually help boost that candidate's chances. Well, some places actually have rules against doing that, and those rules can have a bigger impact on minority voters.
Wow. So many ways to tilt the scales. It's not just about outright denying someone the right to vote. It's about making it harder for their vote to actually count.
You got it. And it gets even more complex because the Act also considers socioeconomic factors that can make it harder for certain groups to participate in the first place.
So things like, poverty or lack of education, those things can impact voting too.
Absolutely. If someone can't afford to take time off work to vote, or they can't get to the polling place, or they don't even understand what's on the ballot, well, then their right to vote is kind of meaningless, right?
Right. It's like having the right to eat but not having any food. The act seems to be saying that voting doesn't happen in isolation. It's connected to, real life.
Precisely. And it's not just about individual voters either. The act specifically protects what are called cohesive coalitions of different minority groups.
So like different groups banding together to fight for a common cause.
Exactly. So you could have, say, a coalition of African American and Latino voters, and they would be considered a protected class under the act if they meet those criteria for vote dilution that we talked about. It's about recognizing the power of, well, solidarity.
Solidarity, shared interests, trying to rig the game. I'm already starting to see why this act was so necessary. And we've only just scratched the surface of Section 2. It's clear this isn't just some abstract legal stuff. It has real consequences for how our elections work, who has power and whose voices actually get heard.
Yeah.
But we've only just begun, right? There's more to explore.
Oh, yeah. Section 2, it doesn't end there. We've talked about vote dilution, but it also tackles vote denial and abridgment. Think of it as going from weakening someone's vote to straight up blocking it.
Ooh, that sounds even sneakier. But before we get into that, I want to hear from you, our listener. What do you think about when you hear obstacles to voting? What are the things that could make it harder or even impossible for someone to vote? Think about that for a minute, because we're going to explore that very question right after this.
So you asked our listeners to think about obstacles to voting, right? It's a good question to think about, because some of the biggest hurdles, they aren't as dramatic as you might think.
Yeah, it's not always about like some big conspiracy or someone literally stopping you from voting. Sometimes it's the little things that just make it harder, especially if you're already dealing with a lot of other stuff in your life.
Exactly. And that's where Section 2C comes in. This part of the act really gets into the nitty-gritty of what counts as vote denial or abridgment. It's like drawing a line and saying, nope, this is not okay.
All right, I'm ready to hear where they draw that line. What does the act actually say about denying or abridging someone's right to vote? Like, what makes it a violation?
Well, it basically comes down to this. If a rule or process makes it harder for a protected group of voters to vote than it is for other voters, those burdens are tied to discrimination, social or historical, then boom, that's a violation.
So it's not just about inconvenience, it's about making things harder for specific groups of people who have already faced discrimination in the past.
That's it. And here's a really important point. The actual number of people affected doesn't really matter.
Wait, really? So even if a rule only affects a small number of people, it could still be against the act.
You got it. The act recognizes that even small-scale discrimination can discourage people from voting. It's like a warning, we're watching you, and we're not going to let you mess with anyone's right to vote.
I like that. It's like saying, we see what you're doing there. But we keep talking about this idea of social and historical conditions. Can you maybe explain that a little bit more? How does the act connect what's happening now to, past discrimination?
Well, it's all about understanding that discrimination doesn't just disappear overnight. It can stick around in laws and practices, even if they seem neutral on the surface. It's like one of those optical illusions where you see one thing, but there's actually something else hidden there.
So even a small change to voting rules could have a big impact on certain groups, even if it doesn't specifically say so.
Exactly. It's about understanding the context. And just like with vote dilution, the courts have to look at the totality of circumstances for vote denial and abridgment cases too.
Okay, so we're back to the big picture. What are some of the things that a court would consider in these cases? What are they looking for?
Well, they'll look into whether there's been a history of voting discrimination in that area and whether they're doing things that go beyond what federal law requires and might be making it harder for minorities to vote.
What are some examples of things that go beyond what's required? Things that might seem reasonable but are actually creating barriers.
Okay, think about things like requiring a photo ID to vote or making people show proof of citizenship or even proof of residence that's more than what federal law says. To some people, those might seem like common sense things, but they can be a real burden for certain groups who might not have all those documents.
Right, like if you're older and don't drive, getting a photo ID can be a real pain. Or if you've moved around a lot, maybe you don't have all your paperwork in order. And depending on the area, these rules could be a way to keep certain people from voting.
Exactly. And the court will look even deeper. They'll also consider things like, Are politicians using racial stuff in their campaigns? And have elected officials been responsive to the needs of minority communities?
Wow, so it's not just about the rules themselves, it's about the whole political environment around the election.
Absolutely. It's about looking at the whole voting system, the context, the history, what's happening politically right now. The Act recognizes that it's all connected, but it's not just about the past and present. It also tries to prevent future discrimination. And that brings us to Section 2 and something called retrogression.
Retrogression sounds kind of serious, like going backwards in time. What does that mean when it comes to voting rights?
It basically means taking a step backward with voting rights. Anything that makes it harder for people to vote based on their race, color, or language, that's retrogression. And the Act says this applies to anything that happens after January 1st, 2021. No backsliding.
So it's like saying, we've come this far and we're not going back.
Exactly. But there is one exception to this whole retrogression thing.
There's always an exception, right? What's the exception?
It has to do with decisions made by the U.S. District Court for the District of Columbia on preclearance applications under Section 5 of the Voting Rights Act. We're going to talk more about preclearance later, but basically this exception says that sometimes a court might have to make changes to voting rules, even if those changes could technically be seen as retrogression.
So sometimes a step back might actually be necessary to make things fairer overall. It's about nuance, right?
Precisely. It's about understanding that the law isn't always black and white. There are gray areas.
Speaking of gray areas, let's talk about these preclearance provisions. This is where the federal government steps in to make sure states are following the rules, right?
Yes. Sections 4 and 5 are all about setting up federal oversight of voting in certain states and areas. And this oversight is triggered by, you guessed it, a history of voting rights violations.
Federal oversight. Sounds like someone's getting a report card on their voting practices.
Yeah.
So how do they decide who needs this extra attention? Is there a certain number of violations that triggers it?
There is. It's not just random. It's based on how many voting rights violations have happened in the past 25 years. Think of it like 3 strikes and you're out.
Okay, I'm listening. What's the magic number of strikes?
The most serious level is 15 or more violations statewide. That's a pattern of behavior. Then there's 10 or more violations statewide, but at least one of them has to be committed by the state itself, not just a local area.
So they're paying attention to whether the state government itself is part of the problem. Makes sense.
Right, it's about accountability. And the last level is 3 or more violations statewide, but the state itself has to be in charge of the elections in those areas.
Interesting. So the number of violations matters, but also who's running the elections. More responsibility for the state.
Exactly. And this is a big shift. It means that preclearance is now focused on specific areas with recent problems, not just geography.
So going from a broad approach to a more targeted one makes sense.
You got it. Okay, so once a state or area is flagged for preclearance, what happens next? What kinds of changes will trigger federal oversight?
Yeah, what are they watching for?
That's where something called covered practices comes in. Section 4A of the Act has a list of voting practices that could be discriminatory and need preclearance.
Give me some examples. What kind of changes would make them say, hold on a minute, we need to take a closer look?
Okay, well, one example is changing the way an election is run, especially adding at-large seats in places with diverse populations. That would need preclearance.
Why would adding at-large seats be a problem? Help me understand that.
Okay, so imagine a city with different racial or ethnic neighborhoods, and they used to have district elections. Each neighborhood could elect someone who represented them. But if they switched to at-large elections, where the whole city votes for everyone, that could dilute the power of those minority neighborhoods, especially if the majority votes together as a bloc.
Ah, so their votes wouldn't have as much power in the at-large system.
Exactly. And the Act is trying to prevent those kinds of things.
Okay, that makes sense. So changing the way elections are structured, that's one thing. What else is on the list?
Changing the boundaries of voting districts to reduce the number of minority voters, that's another one. And of course, redistricting plans. Any plan that unfairly impacts minority groups, especially if their population is growing, would be looked at carefully under preclearance.
So they're trying to anticipate the ways that voting maps can be used to give some groups an advantage over others. Smart.
Right. And it's not just about maps. If a state tries to make people show more documents or add qualifications that are stricter than before the Act, that would also need preclearance.
So like stricter voter ID laws. Those would be flagged.
Exactly. I remember that retrogression exception we talked about earlier. This is where it's important. If a court has already said a practice is discriminatory and a state tries to bring it back, That's going to be a problem.
They're not going to let them get away with that.
Nope. And there's more. The Act also looks at things like reducing multilingual voting materials. For communities where English isn't the main language, they need to be able to access information in their language.
Right, language shouldn't be a barrier to voting. Makes sense. What else?
Any changes that reduce the number of voting locations or move them around, especially if it affects minority communities, those need preclearance too.
So they're watching out for things like closing polling places in certain neighborhoods. Got it.
Yeah. And last but not least, any new processes for keeping voter registration lists up to date, if those processes could unfairly impact minority voters, those also need preclearance. They want to make sure the lists are accurate and no one is being removed improperly.
Okay, they're really trying to think of everything. It's like they're creating a system that's fair for everyone.
That's a great way to put it. But there's another important piece to this whole preclearance thing: transparency. Wouldn't it be great if everyone had clear, easy-to-understand information about any changes to voting rules?
Sure, knowledge is power, especially when it comes to voting.
Right. And that's where Section 6 of the Act comes in. It says that any changes related to voting, things like qualifications, rules, procedures, even changes to polling places or voting districts, all of that has to be announced publicly.
So they can't just sneak in some changes without anyone noticing.
Exactly. And the Act is very clear about this. The announcements have to be made in a timely way, and they have to be easy for people to understand. No more hiding the ball.
No fine print or legal jargon. Got it.
And the Act also knows that voting rights don't just enforce themselves. So Section 12 gives the Attorney General the power to investigate and enforce voting rights violations.
Ah, so there's someone to make sure everyone's playing by the rules. What kind of power does the Attorney General have? Can they just stop an election if they think something's wrong?
Well, it's not quite that dramatic. But the Act says that the Attorney General can demand information from states and local governments. They can ask for documents and data to figure out if something's going on. And if those demands are ignored, they can take it to court.
So they can force them to cooperate.
Exactly. And this power applies to everything in the Act: vote dilution, vote denial, retrogression, preclearance, all of it.
Wow, we've covered a lot. This John R. Lewis Voting Rights Advancement Act is a pretty complex piece of work. They really tried to think of every possible way that someone could try to undermine voting rights and put in protections.
It's a big one. It tries to update and strengthen voting rights in a way that makes sense for today's world. But it's important to remember that the Act's success will depend on how it's implemented and how the courts interpret it.
It's like having a great plan, but you still need people to follow it.
That's a good way to put it. And that's something we all need to pay attention to.
Right. We can't just assume everything will be fine. We have to stay informed and involved and make sure elected officials are doing what they're supposed to do.
Exactly. We all have a role to play in making sure this Act does what it's supposed to do.
Well, we've really dug into vote denial and abridgment, preclearance, the Attorney General's powers, all of that. This John R. Lewis Voting Rights Advancement Act is a pretty landmark piece of legislation. But we haven't really talked about the man himself, John Lewis, a man who dedicated his life to the fight for voting rights.
Yeah, we can't forget about him. His legacy is all over this Act.
It's incredibly fitting, isn't it? This act, with his name on it, is addressing the challenges to voting rights that we're facing today. It's like carrying on his fight. So stay tuned, because we're going to explore the heart and soul of the John R. Lewis Voting Rights Advancement Act next. Okay, so we've made it through this massive deep dive into H.R. 4, the bill that became the John R. Lewis Voting Rights Advancement Act. From vote dilution to preclearance, even the Attorney General getting involved, it's a lot, right?
It is, but what really stands out is how this Act tries to protect the right to vote while still respecting the state's role in elections. It's a tough balance.
Yeah, it's not about the feds taking over everything. It's more like, setting some ground rules and making sure everyone plays fair. And speaking of fairness, we have to talk about the man this act is named after, John Lewis, a true American hero who fought so hard for voting rights.
It's so appropriate, isn't it? His legacy is woven right into this legislation. This act, with his name on it, is taking on the new challenges to voting rights that we see today. It's carrying on his fight, in a way.
It really is. And as we wrap up, I think it's important to remember that the real impact of this act is still unfolding. It's one thing to have a law, but it's another to see how it actually works in the real world.
Exactly. Laws aren't just words on paper, they're living things. They change based on how people interpret them, how they're used in court, and what's happening politically. And that's where you come in, dear listener. You're not just watching this happen, you're part of it.
That's right. We can't just assume everything will be okay. We have to stay involved, stay informed, and hold our elected officials accountable. So, what can our listeners do to keep track of how this act is being implemented? What should they be paying attention to?
Keep an eye on what's happening in your own state and your local community. Are there any changes being proposed to voting laws? Do those changes trigger the preclearance stuff we talked about? Are there any lawsuits about the act? These are all things you can follow and learn about. Remember, knowledge is power.
It's like we've given you the tools, and now it's time to use them. Pay attention to who's running for office, what they think about voting rights, and whether they're supporting the spirit of this act.
And never forget how important your right to vote is. People have fought and died for that right. John Lewis's life shows us that. Don't take it for granted.
Absolutely. As we wrap up this episode of Study Hall, remember, knowledge is power. And when it comes to voting rights, that power is in your hands. Stay curious, stay involved, and stay active in shaping our democracy.
Thanks for joining us on this deep dive.
Until next time, keep learning and keep those brains buzzing.